takes a lot of efforts in organizing, and our endeavor will remain that we will touch upon the alternate remedy, because there have been a lot of cases where the writ petitions have been filed in courts today without addressing alternate remedy, and courts have been imposing costs in a lot of these cases. So I think our endeavor will remain to touch upon this important aspect, because all of us are professionals and it is our duty to take the matters in the court and express ourselves and articulate ourselves well enough before the court. So that is the first issue which we will take. The second would be on the block credits, because subsequent to this decision, which we argued before Supreme Court for several days now, that this order has been pronounced, it is very important to understand the aftermath of this. What are different permutations, combinations, and situations which need to be addressed? Is there a need to go to the writ court again for those matters which are not there, and things like that? So, Nitin, how would you like me to cover? Should I start with the block credit first and then go to alternate remedy? Because I think.
So I think alternate remedy would be the first topic we should be start with, because it has lots of questions with our delegates and all these participants. So if sir can start with the alternate remedy, that will be much better.
Sure. So, what is this alternate remedy? And when we are going to the courts, the first and the foremost question which is being asked by the courts in especially in a writ court is that, do you have an effective and efficacious alternate remedy? Why you are coming to this court? Now, there could be writ of certiorari, there could be writ of mandamus. The objectives of both the writs are different. So, for instance, if there is a situation wherein the tax authorities or the government officials are not taking any action, or the action is inappropriate, etc., writ of mandamus would be the likely writ which would go, for which the alternate remedy is easy to be justified. But when it comes to situations wherein we are challenging the orders in origins, when we are challenging the show cause notice, the first and foremost bridge which needs to be crossed is on alternate remedy. And very important aspect for all of us, which we must understand when it comes to alternate remedy, is the famous decision of Whirlpool. And I would not divide that entire discussion into three parts, but into four parts. And how you could substantiate to the court that alternate remedy is not effective, and hence we have come to the court. So I think first and foremost, the governments must be very clear whether there is an alternate remedy present or not, whether it is effective or not, and lastly, how I cross this bridge of alternate remedy in light of four broad principles which have been laid in Whirlpool. So, what are these four different aspects? We often go to the court and our prayers are very categorical in terms of enforcement of fundamental rights. When we are making our arguments, we must be very clear that which fundamental right has been encroached, and what are our specific prayers. So we must not casually use Article 19(1)(g). If it is Article 14, we must come to very specific that what is the arbitrariness. Are those two principles of Article 14 being addressed or not? So I think those are important aspects which we must highlight very categorically, where we are putting specific governments with respect to alternate remedies. So the first and the foremost aspect remains with respect to enforcement of fundamental right. And if our situation demands that there is lack of intelligible differential between the two situations, then the most important aspect is that one line with respect to that must come in an government for alternate remedy that helps the courts, that helps our case. So the first aspect I would always put is how our fundamental rights have been contravened. That remains the first question. In a lot of these situations, when especially we are taking the show cause notices or the order in origin to the court, we must try to see whether there is a violation of the principle of natural justice. Because even in the case of Whirlpool, it has been very categorically held that in case of violation of the principle of natural justice, alternate remedy would not work. and you could go to the writ court. So it could not be a situation where opportunity has not been given, a simple thing like that. It could be several other aspects where I need to demonstrate that there has been a violation of principles of natural justice. That remains the second point. Third, we have debated and discussed and articulated lot about the jurisdiction, and we have seen that what has happened in Canon. What happens when these notices are being issued, whether these are issued by the central authorities, whether these are issued by the state authorities, whether there is an overlap. So I think the third and the foremost aspect, which is very relevant and which allows us to cross the bridge of alternate remedy, is the jurisdiction aspect. So if we can prove that these proceedings are wholly without jurisdiction, then we can cross this bridge of alternate remedy. When we talk about jurisdiction, it could be territorial jurisdiction, it could be in terms of his powers, and so on and so forth. Are there duplication of efforts by the state and the central authorities? Can DGGI issue the show cause notices and also adjudicate? Whether DGGI can also issue show cause notices for several other states, etc., remain a question mark, remains a point which needs to be demonstrated to the court. Are there duplication of proceedings? Lately, there have been, what I understand, thousands, maybe thousand is a understatement, maybe lakhs of show cause notices which are underway, and we would see in next couple of weeks there'll be thousands and lakhs of such notices which are now being issued by the state authorities. And these notices are issued basis the reconciliation between 3A, 3B, 2A, 2B, 9C, etc. Now, what they're doing is they're issuing these mostly from the reconciliation perspective. What remains to be seen is that for a particular period, if the central authorities, for instance, DGGI in a particular case, has already issued the show cause notice, has already concluded on the investigation, whether state will have the jurisdiction again. And those are important aspects which need to be seen from the perspective of alternate remedy. What also has to be seen is that, for instance, if the federal authority has already taken all books of accounts from me, but has identified two issues, the question remains that when I have given all of these books of accounts, all information to the tax authorities, can the state authorities now, once, for instance, the federal authorities have already issued me a show cause notice, can identify different issues based on the same documents? So that needs to be tested in courts based on specific facts and circumstances. So from that perspective also, the decision of the Whirlpool in terms of the jurisdiction, test of jurisdiction, remains important and remains to be averred and remains to be an important part to be averred in the writ petition. Last but not the least is when we are challenging the vires of the act or a provision. Now, here clearly there is no alternate remedy, but what happens sometimes is we are not able to substantiate in terms of prayers that what exactly are we challenging. And we've seen that in some of these cases, while there is a clear intention to challenge something, if the averments for alternate remedy or in the prayers there are specific non-mentioning of these provisions, then the court may be a little hesitant. We have seen, lately courts have imposed costs as high as 5 lakh rupees in certain cases, and in several other cases, because today the courts are flooded with petitions. They also want to test, first of all, before going into any of these provisions, into how and why the alternate remedy is not effective. So I think both from the effective perspective and efficacious perspective, we must have very, very clear averments in terms of alternate remedy. Alternate remedy also comes into play for certain other aspects. We have seen that there are a lot of contractual disputes related to GST which are coming to the court. And sometimes these contractual disputes are not between private parties. These could be with the semi-government government authorities as well. Now, what happens in that, if there is a contractual dispute, then could you go to the court? Should you And what happens if there is an arbitration clause? Now, as far as the discretion of the court is concerned, under 226, court has wide discretionary powers. There is no doubt about that, that court has wide discretionary powers. But what happens, because the court may say that you go to arbitration, you proceed under arbitration, and possibly this is a contractual dispute. If it's a contractual dispute, why do you want to come to the court under 226? So I think, first of all, we must again take a pause and check whether those four fundamental aspects of Whirlpool are applicable. I may have a contractual dispute coupled with the fact that I may have dispute with respect to one of those four aspects. And if that is the situation, then I can very well to the court that holistically the issue has to be looked into. It is not only the contractual dispute which is important and needs to be addressed, but also one of my 4 points addressed by Whirlpool. So that remains an important aspect. With respect to the contractual disputes, whether these could be addressed by the courts, there are certain decisions of the court, and I have this decision before me. In case of, let me just tell the name, and these remains important ones to be addressed. So, for instance, the Supreme Court, in case of ABL International, the court has addressed that how contractual disputes can also be addressed and how courts have wide discretionary powers. So what happens, what are the findings in this? I will just read that the court says, this clearly shows that in an appropriate case, the writ court has the jurisdiction to entertain a writ petition involving disputed questions of facts, and there is no absolute bar for entertaining a writ petition, even if the same arises out of a contractual obligation and or involves some disputed questions of facts. So here there are two important aspects. It is not only the contractual obligation, but also the disputed questions of facts can be addressed by the court under 226. But I think we'll have to be very, very careful when it is only with respect to the contractual aspects. Now, a lot of times there are certain cases where price escalation may happen, where there could be different issues with respect to, for example, there could be an arbitration clause. So what happens in those? So in case of Ram Barai, Supreme Court has very clearly held that even if there is an arbitration clause, that would not be a bar. And I will read that paragraph. The court says that a constitutional remedy by way of a writ petition is always available to an aggrieved party, and an arbitration clause in an agreement between the parties cannot ipso facto render a writ petition not maintainable as wrongly held by the division bench. So I think both on the presence of an arbitration clause and for a contractual dispute, you could again go to the writ court, but it remains to be seen that how facts have been put together, how these are portrayed, and so on and so forth. One very interesting decision with respect to this is Unitech decision of the Supreme Court, and this is addressing all of those grounds with respect to the contractual disputes, with respect to the alternate remedy, and importantly, it goes over and above that to the reasonable and fairness as well. And the court says that if the state instrumentality violates its constitutional mandate under Article 14 to act fairly and reasonably, relief under the preliminary powers of Article 226 can be lie. So I think this decision, Unitech, addresses not only various aspects, but how to cross, and of course, the principles laid down in Whirlpool have also been addressed here. And importantly, what court says is this, that while exercising its jurisdiction under 226, the court is entitled to inquire into whether the action of the state or its instrumentalities is arbitrary. So when we are challenging anything in terms of Article 14, I think this decision becomes very, very handy because it also goes on to the state action being arbitrary. And from that perspective, this is an important one which we must keep in mind. So I think broadly from that perspective, if we were to submit, then I think the broad principles of this alternate remedy revolves around those four important aspects: whether there is an infringement of my fundamental right,
Recording in progress.
violation of the principles of natural justice, on jurisdiction, and last but not the least, if I'm challenging the wiry. So around those, if the entire petition revolves and we are able to cross, then I don't think any court will have a problem with respect to alternate remedy. If we are unable to address four of these principles in Whirlpool, then of course we will have to see what exactly are the facts. How do I cross this? Can I use the findings in Unitech to say that there is an arbitrary action or manifestly arbitrary way which can be demonstrated, and hence I have come to the court? So I think with respect to alternate remedy, these are some important aspects which must be kept in mind, because courts in these days are very, very strict to examine this issue of alternate remedy. There will be a lot of show cause notices and orders which will be issued now in the near future, and hence we must not straight away go to the court, because courts are looking these issues very, very seriously. What we must do is understand and ask several questions to ourselves whether the appeal is an effective way to address this. If I go to appeal, what is the hardship? And we have heard some of these arguments where people say that this pre-deposit is a burden to me. The court is not bothered. I mean, because if you're doing business, the court may not be bothered. Even if you try to prove on financial difficulty, etc., the court may not be bothered. So a lot of times, in fact, we have seen arguments where court is specifically asking that why we should not impose cost on you. The advocates are not able to justify that why cost should not be imposed. And then the court is writing that once it is being asked that why cost must not be imposed, no answer was given. So I think this remains an important aspect in our professional journey. While writ court remains a useful weapon, it must not be a weapon which must be used in all circumstances. Effective remedies other than the writ remedies must also be explored so as to justify our action and submissions before the court. So that is with respect to the alternate remedy. And with this, it brings us to the next aspect of blocked credits. I can take a pause in case any one of you has some specific question. We can raise that question now on alternate remedy or constitutionality of any aspect, and then possibly go. I will leave it to the audience.
It is requested that if anybody is having any question, they can directly put up in the meeting chat. We can directly ask through the chat option regarding alternate remedy and when to go before the honorable court directly without going to the alternate remedy of appeal. Sir, I guess, sir, as of now, there's no question, and maybe it will come later on in the question and answer session.
No problem. So what we can do is we can go ahead with the second part of the presentation and then address all of these questions together as and when these are posted. The second aspect which we are talking today is with respect to the blocked credits. Now, all of us know as professionals that there are certain provisions under Section 17(5) which relates to blocking of credits under certain circumstances. The first and the foremost question which arises is whether today there could be provisions in law and statute to block the credits, because that is against the fundamental principles of GST. You are blocking the credits. So under what circumstances that can happen was the question which was raised by industry, different sectors. Matter was addressed in case of Safari by Odisha High Court, and then the matter went to the Supreme Court. It was not only the revenue which filed an SLP against Safari order, but we also filed an SLP and writ petitions separately in Supreme Court. There were a lot of questions which were asked that how, if I have not been engaged by Safari, could file an SLP with respect to the order of Orissa High Court. I may be aggrieved by the Safari order of Orissa High Court, and under constitution provisions, I can still challenge the order which may not relate to me. And hence, what we had done was we had filed not only the writ petition in Supreme Court for different clients, but also challenged Safari order. While Safari was not my client, still challenged Safari to say that in terms of reading down and in terms of constitutionality, more needs to be looked into. So with that background, we went to Supreme Court. We had several writ petitions, SLPs, IAs, etc. And what was the main issue before the court? And before we address the main issue, I think what is very important for us is to first understand some of the interpretations, some of the rules, principles which govern the interpretation of the taxing statutes. Once we understand that, I think it is not only today the Safari decision or other decisions which are coming in the writ court, but these interpretation of taxing statutes, these principles remain very important. And I think I would want to touch upon that for a few minutes and then we will proceed. So, as far as the taxing statutes are concerned, a taxing statute must be read as it is with no additions and no subtractions on the grounds of legislative intendment or otherwise. These are several principles which are coming from different court orders over the period of time, over 5 decades, and so. The second is with respect to the language. If the language of a taxing provision is plain, the consequence of giving effect to it may lead to some absurd result is not a factor to be considered while interpreting the provisions. It is for the legislature to step in and remove the absurdity. These are some of these principles. There could be certain exceptions. We'll come to that as well. The third is that while dealing with a taxing provision, the principle of strict interpretation should be applied. And this was also one of the key factors in case of the decision of Safari, that whether there must be a strict interpretation of these provisions of section 17(5) and D, or whether there can be some deviation. We will come to that. Fourth principle is, if two interpretations of a statutory provision are possible, the court ordinarily should interpret the provision in favor of a taxpayer. This is very key. And this is what we use in a lot of these writ petitions which we take. We try to impress upon the court that there are different interpretations which are coming for the statute. And once different interpretations are coming, there are a lot of precedents that for different interpretation, the court will have to tilt in favor of a taxpayer and against the revenue. This is very, very important principle which we use and must be used very often. The fifth principle is, in interpreting a taxing statute, equitable consideration are entirely out of place. So when it comes to interpretation of a taxing statute, hardship, etc., this thing is all out. Equitable considerations are entirely out. And a lot of times when writ petitions are filed in the court, the lawyers are addressing on equity. Now, that is not applicable as far as the taxing statute is concerned. So, the sixth principle is, a taxing provision cannot be interpreted on any presumption or assumption. So, as far as any presumption or assumption is concerned, for interpreting a taxing provision, you cannot have any sort of an assumption. Seventh, a taxing statute has to be interpreted in the light of what is clearly expressed. And we will see how Safari this was very relevant. What is clearly expressed? The court cannot imply anything which is not expressed. Moreover, the court cannot import provisions in the statute to supply any deficiency. And hence, that entire discussion of plant or machinery was very relevant, because court said that we will not be able to import any provision into these phrases, and it made our life a little tough to justify to the court that how these are different and things like that. The next principle is there is nothing unjust in the taxpayer escaping if the letter of the law fails to catch him on account of the legislature's failure to express itself clearly. The next principle is if literal interpretation is manifestly unjust, and this is very important. If literal interpretation is manifestly unjust, which produces a result not intended by the legislature, only in such a case can the court modify the language. This is very important because we are now asking the court to read down the provisions or to modify the language in such a way, and there we will have to go on to the literal interpretation and say that this is manifestly unjust. It is not the intention of the legislature, and this remains a very, very important tool or a principle which must be used in the tax petitions. Equity and taxation, as I mentioned, are strangers, but if construction results in equity rather than injustice, such construction should be preferred. Courts have held, even with respect to equity, while the courts and the cases which we have seen are very, very clear, but there is an exception to that as well. If the construction results in equity rather than injustice, such construction should be preferred. The next important principle is it is not a function of the court in the fiscal arena to compel the parliament go further and do more. So, the courts have held that over the period of time, and hence when we are challenging the vires, we a lot of times make GST Council a party, and we put that, but that has a very limited role in a way, unless and until the vires result in a provision being manifestly arbitrary, then or lack of intelligible differentia, etc., then the situation is different. The last principle which I want to highlight to you is when a word used in a taxing statute is to be construed and has not been specifically defined, because here again Safari was of relevance because plant and machinery and what the principle is, and we have laid down all of these principles while arguing before the court. We submitted that when a word used in a taxing statute is to be construed and has not been specifically defined, it should not be interpreted in accordance with its definition in another statute that does not deal with a cognate subject. It is very important because a lot of time revenues would refer to something else, or we as lawyers would refer to something else, but there are strict principles. It should be understood in its commercial sense, and that's the key. It must be understood in its commercial sense, and you cannot just borrow the definitions from the other statute if that statute does not deal with a cognate subject. Unless defined in the statute itself, the words and expressions in a taxing statute have to be construed in the sense in which the persons dealing with them understand. That is, as per the trade understanding, commercial and technical practice and usage. In most of these cases where we go to the court, the commercial sense is completely in our favor, but we very, very frequently use the common definitions in different statutes. But there are clear guidelines while interpreting that you should not do that. You should actually go into the commercial sense. You should go into the commercial sense, trade understanding, and technical practice and usage. So I think those are important principles of interpretation, which helps us not only to address this question in case of blocking of credits, but also other aspects. So as far as Supreme Court was concerned, there were two issues. There was predominantly an issue on challenging the vires of Section 17(5)(c) and D. The court unfortunately also went into Section 16(4) and has given the finding, but I think to which there will be a separate challenge for sure. So now let's understand that what were few of these aspects. I would not go into the philosophy, etc., into which the court or the order went, but I think the most important question before the court was that Clause C uses the expression plant and machinery, which is specifically defined in the explanation. Clause D uses an expression of plant or machinery, which is not specifically defined. Things like that came to the court, and hence the question before the court was that how this needs to be interpreted, what benefit must be given, and what tests must be laid down. So now let's come to the findings of the court, and what court said and expressed is that the explanation to section 17 defines plant and machinery. The explanation seeks to define the expression plant and machinery used in chapter this, etc. The expression appears in several places, but the expression plant or machinery is found only in section 17.5d, and hence interpretation, strict interpretation, etc., all came into play with respect to the principles which we enumerated before the code, that this now section 17.5d must be looked into that aspect. And what the code said, the code said that functionality test would now be relevant to examine whether you would qualify as plant and or whether you would qualify as machinery. And hence the court said that whether a building is a plant is a question of fact, and the court said that it has held on facts that a building has been so planned and constructed so as to serve an assessee's special requirements, it will qualify to be treated as a plant for the purposes of investment, etc., and relied on income tax decision. So the main aspect before the court, so the court went a little ahead, apart from the statements and objects of GST, tax cascading, seamless credits, etc., etc., and went into the functionality test and other tests, and then divided the entire discussion into various things. So, for instance, what happens for a commercial building? What happens for a multiplex? What happens for the factory? And what Supreme Court did smartly and beautifully was to say that some of these aspects you need to test based on the functionality test and based on the essentiality test. So the court, while it held that these provisions are constitutionally valid, clauses C and D of section 17.5 and 16.4 also it addressed, which was not argued too much, would be constitutional. But the court said that the expression plant or machinery used in section 17.5d cannot be given the same meaning as the expression plant and machinery defined by the explanation. So plant and machinery, it was held to be different than plant or machinery. So what the court said was, the question whether a mall, warehouse, or any other building other than a hotel or a cinema theater can be classified as a plant within the meaning of expression plant or machinery is a factual question which has to be determined keeping in mind the business of the registered person. And here is where the court said that functionality test, the business will have to be kept in mind, and the role that building plays in the said business. If the construction of a building was essential for carrying out the activity of supplying services, and this is very important, and you must note down that in paragraph 65C, the court very clearly says, if the construction of a building was essential for carrying out the activity of supplying services, comma, such as renting or giving on lease or other transactions in respect of the building or part thereof, which are covered under this and this, the building could be held to be a plant. Now here, there are two important aspects. One is the essentiality test. They put down the essentiality test. Then when they're mentioning about the building for a lease purpose, it is only illustrative. They use the word such as. It is only illustrative, which means for this, I will certainly get the benefit, but based on essentiality test, I would get other benefits as well. Then the court goes on to address the functionality test and says that it will have to be applied to decide whether building is a plant. So both the essentiality test and functionality test comes into play. Functionality to determine whether the building is a plant, essentiality test to examine how essential it is for rendering my output taxable supply. And then the court submits that as by using the functionality test in each case on facts in the light of what we have held earlier, it will have to be decided whether the construction of an immovable property is a plant for the purpose of clause D. Now comes the next part where the court says that, this is remanded, etc., etc. Last paragraph, second last paragraph is also very important. And because that will raise a lot of fundamental questions, that whether everybody would get the benefit automatically, what needs to be done. And I have some aspects with respect to that, and we will address that. Para 67 of the order says that while deciding these cases, so the question is whether this decision is co the petitioner or it applies automatically to everyone. It says while deciding these cases, we cannot make any final adjudication on the question of whether the construction of an immovable property carried out by the petitioners in petitions amounts to plant, and each case will have to be decided on its merit by applying the functionality test in terms of this judgment. So the court says that each of these cases will have to be adjudicated based on the functionality test in terms of this judgment. The issue must be decided in appropriate proceedings in which adjudication can be made on facts. Now, the court again says the petitioners are free to adopt appropriate proceedings or raise the issue in appropriate proceedings. When the court uses in paragraph 67, these cases, petitioners, the question remains whether the benefit of this order will go only to these petitioners or whether it will go automatically to others. If it doesn't go automatically to others, what are the things which we must do to be at par? So some of these thoughts which I have summarized here is, can I avail the credit now? Is it barred by 16.4? 16.4 is already addressed to be constitutional here. There are certain extensions for certain years. But what if I have not taken the credit during that time which is being prescribed? There could be two situations. Either I am a petitioner in this batch or I was not before the court. The facts and circumstances based on dates, etc., will be different. The second situation could be that there is an show cause notice which has already been issued to me, but which has not been adjudicated. Can I use the principles in case of this Supreme Court decision? Certainly, yes. Whether I need to go to the writ court for me to be treated equally with respect to the functionality test and the essentiality test will depend on certain facts. But if the stakes involved are huge, it is always good to take the direction from a writ court to be treated at par in light of the Supreme Court decision. The third situation could be, I have availed the credit but not utilized. Can I utilize now? I can certainly utilize now, but subject to me being put to the functionality test and the essentiality test. And how that can happen is by getting a direction from the court if I am not part of that batch in the petition. That I can do. The fourth situation could be, I have not availed it earlier and I have lost the deadline. The extensions do not cover me. This order says 16.4 is constitutional as well. I need to see and check the treatment of these credits in my books, whether taken, reversed, etc., taken and reversed, etc., and things like that. And again, basis the facts, I will have to go either to the court or to the adjudicating authority, basis facts, to get myself adjudicated on these principles which are being held in Safari. There are questions which now will be relevant to situations. What happens that once this is treated once as a plant, sold later, then what would be the tax payable and things like that. So that remains a challenge. There are a lot of petitions or challenges with respect to joint development agreement in case of land. I think which to a very large aspect has been resolved, because now the credits would be available under section 17.5D. So JDA ideally, the credit in those situations must be a pass-through in a lot of situations. So that gets addressed to a very large extent, but certainly will depend on various facts. Works contract, a lot of these transactions are works contract. C remains a problem area. A lot of these transactions which are now happening, The person who wants to procure these services want to now bifurcate the transaction into the labor contract, the goods, etc. The purchases are happening directly. Is that a correct way? Till the time you are able to justify that this is not a just mere mean of tax evasion and the transactions are simple and straight, I don't see that should be a risk. So these are some of these issues which will come up, which are relevant even with respect to block credit. As far as I would want to submit it, that till the time you're able to meet both the functionality test and the essentiality test, be it whatever transaction, you will be able to take the credit. The facts will remain very important, that what is your output service, what are these procurements, how is your building, etc., relevant and essential, what is the functionality test, how these services or procurements which you're doing are essential for making that building, and things like that. Once you are able to cross the test of functionality and essentiality, I think in most of these cases we will be able to claim the credits. Of course there can be litigation at several levels, but the credits can come now and would significantly reduce costs. That is all, I think, from my side, and I'm happy to address the questions on any of this aspect.
If any participant would like to ask any question regarding today's session, they can directly ask and unmute themselves right away. I guess